Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And guys, today yet again, we have some breaking news on the Ripple v SEC lawsuit. It's crazy, it's big, and it's something that you need to know. So let's quickly go ahead and check it out. Ripple v SEC. Parties move jointly for brief extension of fact discovery deadline to take Garlinghouse and Larson depositions and to extend expert discovery deadline until November 12th, 2021. Garlinghouse and Larson's motion to dismiss are pending before the court. The parties are still conducting fact discovery, and the two motions to compel are pending before Magistrate Judge Netburn, and the parties are requesting leave to conduct two depositions in September. The motion to strike and motion to intervene are still pending, and the expert discovery deadline will be extended to November 12th. In my experience, anyone who thinks this case is settling anytime soon should reconsider. And guys, I've explained it a couple of times by now, but let's quickly cover it again. There is first today a telephonic hearing that was called out on August 31st, which was supposed to be the end of the entire, it's going to be the end of the entire debacle here, but now it isn't because it's going to be extended by a little while. But I've explained it for a little while. I thought that this week would be the most important. And, well, clearly it is. But a couple of interesting things have also happened. First of all, Garlinghouse and Chris Larson are apparently going to be deposed. They're going to be questioned, and that's about to be really interesting. I mean, we saw already that there were like another 100 depositions or so which took place from Ripple employees in the past, but still, for the two defendants now in the case to be questioned is going to be very freaking interesting, at least in my opinion. But let's quickly check out this discovery deadline thing. I had so much stuff to talk about today already because of everything that happened, but right now we got even more. So, pursuant to Rule 29B, of the Federal Rules and Procedure, whatever, the SEC and defendants and everybody jointly and respectfully request that the court permit the SEC to conduct depositions of Garlinghouse and Larson after the close of August 31st, 2021 fact discovery deadline. Correspondingly, extend the current expert discovery deadline from October 15th to November 12th, and permit the parties to exchange their respective statements of material facts pursuant to Local Rules 56.1 at a later date, to be proposed by the parties at or around the end of the proposed expert discovery deadline. The parties have submitted as Exhibit A hereto a proposed order reflecting these joint requests. All right, so this is basically from Ripple and the SEC as it's a joint filing. That they wanted to be extended, which from a certain perspective is really odd, from a certain perspective is really logical. The reason I'm saying it's actually quite logical is because, as we've explained before, both Ripple and the SEC have a benefit in making sure that the facts right here are thrown on the table. And now, even though what we're reading here doesn't really look to be in Ripple's best interest, it most likely from some perspective still is, all right? They most likely have some sort of bigger plan as to why Ripple would also want to extend it. But right now, the primary reason I can find is because the SEC wants to depose these two guys. Then again, with still about a week or more in the play here, I do kind of wonder if they're going to depose them for like a couple of days or something. William Hinman was deposed for about 9 hours where he had to talk. And I'm wondering if Brad Garlinghouse and Chris Larson are going to have to like sit there for, 3 days, for example, where they start at 8 p.m. or 9 p.m., whatever, and they stop at 9 p.m., and that 3 days in a row or something like that. Because, well, it's most likely going to be a lot of questions, as we've seen before. Some of the members of Ripple could not answer, for example, or couldn't recall answers to more than 250 questions. And that brings up a couple of points. One, what in the world will they be asking them? Because it's going to be an entire book. It's going to be crazy. Second of all, is it going to be public as well? Will the SEC showcase it, or will Ripple, stop that basically for some other sort of privilege in some degree? I do wonder. At least some parts, I guess, will be privileged yet again. And also, what is going to come out of that? Will Brad Garlinghouse and Chris Larson really kind of say something new right now? Will they just deny everything? Because I would, from a certain perspective, also think that they could just deny or don't talk about anything, right? Because Brad Garlinghouse and Chris Larson, they can basically incriminate themselves. The problem with our situation before with the deposition is that William Hinman can't really do anything, even if he gives the most shittiest answer that we could possibly get. It would just be annoying, but he couldn't really hurt himself too much unless he accepted corruption. And he said, yeah, I just got some money to say that. But no person in the world would ever admit that, I think, right? If he's in such a position, he got pretty far. He wouldn't admit that, I think. However, Brad Garlinghouse and Chris Larson, they're two individuals. And so the pressure on them to question or to answer those questions is a lot more severe. And I do wonder, because I do think depositions, no, I actually know for a fact, can actually be just completely silent, where you basically just give no answer to any questions. Then again, it might not be in their best interest for the judge to not do that, but it's definitely interesting. All right, let's put it like that. It's interesting. I do wonder what's going to happen. Then depositions after the fact discovery deadline. Fact discovery currently is scheduled to close on August 31st. However, due to the unexpected illness of an attorney from one of the parties who was integral to the Larson deposition and the intervening vacation schedules of other attorneys, the parties will not be able to reasonably complete the previously scheduled depositions of Garlinghouse and Larson before August 31st. And accordingly, the parties respectfully requested the court, for good cause shown, allow them to conduct 2 depositions after the close of fact discovery on September 14th and September 20th. This is the parties' first request to conduct depositions beyond the close of fact discovery. Other than these 2 depositions, fact discovery would close as scheduled on August 31st. So, well, basically, the official deadline has not been extended from August 31st, right? For the normal fact discovery, basically. Let's actually quickly check it out here, right? So on James Fillin's Twitter, we a little bit earlier had a, damn, I don't think I'll be able to find it anymore. There was basically a good overview of the dates, the most important dates. Let me quickly see if I can scroll through here and find it. Here we go. Right, so we got August 31st as a fact discovery deadline, and then October 15th as the expert discovery deadline. So fact discovery, expert discovery. Now, this fact discovery is not really moving at all, right? Still on August 31st. Yet, they're basically saying, hey, we were supposed to get some facts in this, part. We were supposed to depose those 2 guys, yet we're not going to make it. So we want to kind of do that after the deadline. They have to question for that, or they have to put up a filing for that, which most likely just have to do with the fact that some of the lawyers will be on vacation and one of the guys was sick. I mean, it's a time where people can be sick, for really understandable reasons. You'll have to move things right now. I mean, getting sick right now in an area like this is so much more understandable than usually. It's like, if I think back 3 years ago, for example, somebody said, oh, I'm sick, let's move it by a month. I'll be like, what? What are you talking about? You're sick? So what's the problem? You're not gonna come to work tomorrow? But now it's like, oh, okay, never mind. Yeah, let's see what we can do. All right, because sickness has just become such a more important part, I guess, in these types of ordeals. I'm not sure though. Maybe in the law field, if somebody gets sick, things always get extended because they don't really care. They want, they make more money anyway that way. But in my own opinion, I usually find that people keep working even though they're sick. But of course, we don't have the sickness here as well. It could be that it's something really severe actually. So I shouldn't downplay it. It could be a lot of things. Now, expert discovery deadline. On June 2nd, the SEC moved to extend the original fact discovery deadline by approximately 2 months, from July 2nd to August 31st for fact discovery, and from August 16th to October 15th for expert discovery. And that was granted by Judge Netburn. As noted above, the parties will be unable to complete depositions of Garlinghouse and Larson by that time. Expert reports were initially due under the current schedule on September 10th. The deposition testimony of these individuals could affect the content of the parties' contemplated expert reports, and accordingly, the parties respectfully request that the court correspondingly extend expert discovery until November 12th, with opening expert reports due on October 4th, to allow for the same amount of time between completion and those depositions and expert reports as under the prior schedule. All right, and then we have statements of material facts pursuant to Local Rule 56.1. Let's actually quickly check it out here. Paragraph 8 and 16 of the court's case management order and Rule 3C of the court's individual practices together require the parties to exchange their respective 56.1 statements before the parties file the opposing party's response to 56.1 statement with their pre-motion letters regarding motions for summary judgment. Well, under those procedures, the parties' statements are due in early September, before the September 14th deadline for pre-motion summary judgment letters. So they're basically just saying, hey, it's due for a specific date. before the deadline. However, Garlinghouse and Larson's motion to dismiss are pending before the court, and the parties are still conducting fact discovery. 2 motions to compel are pending before Magistrate Judge Netburn, and the parties are requesting leave to conduct 2 depositions in September. The parties also expect that expert discovery will affect the contents of their respective 56.1 statements. And accordingly, the parties respectfully request that they be permitted to propose a briefing schedule for summary judgment and or pre-motion conference letters and the exchange of 56.1 statements at a later date. In any event, after the close of expert discovery. So in this specific part here, they don't necessarily want to extend expert discovery, but they're saying, hey, we have a specific letter due on early September, yet because of everything that's still happening, we have so many issues open right now, 2 motions to compel, there's a couple of depositions and whatnot. Well, we actually want to file these letters to each other a little bit later, even though they're required for the case. We want to do it later because once more, there's just so much that we're waiting for and that could change everything that we have to give over in our official reports, basically. This is the party's first request for a modification of the schedule for 56.1 statements and pre-motion summary judgment letters, except insofar as the SEC's request for an extension of discovery schedule described in Section 2 above altered the 56.1 statements and pre-motion summary judgment deadlines. All right, so I'm not too sure what the pre-motion summary judgment letters normally would mean. Again, I'm not a lawyer, so don't ask me about that. What I feel as if it's just a letter that you file to the other party, which is the court, before you actually file your motion for summary judgment, right? Because it's a pre-motion summary judgment letter. So it's just something which you file to be able to file your motion for summary judgment, which is usually what they do in these cases. It's like you file a letter in which you basically ask if you can file or get a conference going or whatnot, or basically file your official motion. You basically request that first. And maybe that is this letter, right, that they're talking about, the request to file the official motion. But again, I'm not sure about that. And here was the proposed order granting the parties joint motion to extend the deadlines for deposing certain witnesses, completing expert discovery, and postponing the filing of ruling. Wait a minute. I actually did not check this one out. I'm seeing here. This is a proposed order. So, is this a hypothetical or something like that? Proposed order? Because it's actually a grant by the judge. Oh, never mind. Okay, so I got it now. Because actually, no, never mind. I did see this before. I'm like, what is going on here? I was completely confused. I was like, has there been something added? I'm like, hey guys, make sure you understand. I usually read these things a couple of hours in advance before I start recording the video. So in this case here, I got confused. I was like, no, wait, I forgot something to completely check out. But no, I didn't. What this basically is the judge usually just checks this proposed little file out. And she basically just signs it with the date and her name or her signature if she agrees to the new scheduling, right? Because they basically, Ripple and Garlinghouse and the SEC have to give over their proposed idea of how to schedule it and put it in a formal letter. And so the judge can basically see, okay, this is the proposed change. It is to basically do these 3 things, which we've covered a couple of times by now before. I agree with that, fine. The date and the name, bada boom, bada bing, it's changed, right? So it's not like, there's so many different points, so many smaller points as well. What exactly are we changing? What exactly are we doing? No, the SEC and Ripple here came together to quickly state what exactly the points are at the end. And yeah, I think it's pretty obvious. But not necessarily bullish, not necessarily bearish, guys. At first, it was like, oh, screw this. I'm not happy with that. That's because things are getting extended. Things are taking longer. And a lot of you guys keep saying, oh, this case is taking forever. It's never going to end. This stupid manipulation and whatnot. And from a certain perspective, I do agree with that too, all right? Because it really feels as if it's never ending. It's always continuing on, and there's just no end to this. Then again, one guy, for example, said, James, do we know who is deposing them? Can their own team do it for evidence, or is it the SEC? And why would they want an extension? If it's the SEC, wouldn't Ripple just say, too late, buddy? It feels like Ripple are already holding enough ammo to move forward. And James said, hey, Ewan, we don't know who is sick or which team that attorney is on. It's purposefully drafted so we can tell if it's Ripple's side lawyer or an SEC side lawyer. So it's a professional courtesy. While this is a battle, the lawyers are still professional with each other. And I guess ultimately, those lawyers don't hate each other. They're both making their money. And obviously, this is a really high-level case here. These are really professional guys. Most likely making a freaking ton of money too in that regard. So they most likely know how to play the game, right? These guys know what they're doing. This is not a kid's game, right? We're talking hundreds of millions of dollars that this case is all about here. So this is going to be a really, really big paycheck for those guys, I guess. But also, I think those two lawyer parties can really understand each other's efforts in this case. They're putting their best foot forward. And I mean, maybe after this case, they're going to get a beer together just for all the effort they put in, because this is a really big fight. It's really also interesting to me. And I do also think those guys don't hate each other, right? I mean, isn't that normal that the lawyers respect each other's sides for just trying their best to sneak things by the judge? And even though, right, they're trying their best to sneak things too, the lawyers should just be able to respect it, right? Because, I mean, you got to do everything to make your side win. And if you do some sneaky tactics, obviously, it is in the best interest of your client to try. Because sometimes, specifically for the SEC's case right here, there's just no winning it the legitimate way. All right, so this is their best option. All right, guys, if you're looking to trade XRP, you might want to check out Bybit. It is the exchange that I personally use. And again, you might like it. All right, so make sure you check it out. A link is down below. Having said that, though, guys, make sure you check it out. There's a couple of bonuses, and there's a big trading competition going on. There's also a multiple thousand XRP giveaway that we can do. But the guys over at Bybit asked me how they want to do it, or how I want to do it. Not sure just quite yet. They said, hey, we can do a 3,000 XP giveaway. I'm not sure exactly how to do it just quite yet. How should we do it, guys? I'll think of something, right? I'll think of something, but it's going to be fine. Thank you for all watching this, and I'll see you guys again in another crypto video later today.